I'm going to tell you something about the legal minefields, especially when it comes to the GDPR. So this is an interesting topic, right? So we want to convey and teach our students on how to deal with personal data in research, and we want to give them a good pathway, a safe pathway. We want to pave the way for them through this minefield. But do we know ourselves as teachers how things work? Huh? And that's a very interesting thing where we have to do it, because I think even up to higher levels at our universities, when it comes to GDPR, there are many things that are not so very clear. For example, when you start working with person data is any data that can lead to an identification of person. The question is first, okay, if we are going to collect or process this data, what's the legal basis to do this according to the GDPR? And so there are 6 of these legal bases that you can use to process data. And at the university, so at my university, consent is the legal basis that you should do to do research. How is this at your university? Who also has consent as the main purpose, the main legal basis? 1, 2, 3, 4, 5, 6. Some don't even know. That's all. I see it in your faces, the panic. And it's also the case at my university. And I'm now working already for months to convince you that this is not the good legal basis. You have to use the public interest thing, because that's the public task of a university to do research. And that's the exact right thing. I know Utrecht has the right legal basis. They do it on the basis of public interest. But it is quite difficult, because if you do it by consent, people can retract their data at any moment, and replicability of your research is really in danger. So really it is things that, and if you deal with social media, students like to work with social media data, but you can't ask everyone that has a post for their consent. So think about this, right? Okay, so that's the first thing. And then when we want to teach our students about this, we have to, and that's what I do in my courses, I go back to some basic principles that are outlined in the GDPR and are relevant, and you can see it throughout this regulation. With the privacy by design in research is not a thing that is right there in GDPR, but there are consequences that you really should work on, and that can be taught to students, right? So there are principles of data minimization, data quality, goal setting, minimization of use, security measures, transparency, rights of data, subject liability, and they all also go back to what the legal basis is and what you're doing. So this is a very relevant aspect. And also what you have to realize, okay, when you do work with person data, are you the processor or are you the controller? And in most of the cases you are controller, but in some cases you have joint controls. And this is also things that you have to realize and think about. Good. Then the other thing is that we at universities, and the whole regulation that I see is typically about processing and collecting the data. But sharing the data afterwards, that's quite a different path. And it's also everything to do with GDPR, but to find the correct regulations for this is quite difficult. So we have this idea that we want open data. But this is not possible in all cases because, for example, you don't have the consent of the participants. And really, if you work on consent, this is elementary. So the basis that we have here is we have to make this data available as open as possible, as closed as necessary. And this can indeed be because there are restrictions on sharing such data. So this is an important element that I see often missing in the regulations that I get from my university, that we really want to share these data. And this is part, and we talked about this yesterday, it's part of the scientific output of our research. It's not publication, but also data sets are very, very relevant outputs. And you can gain a lot as a researcher when your data set it becomes a reference. So archiving and publishing data, there are these 3 levels that we have to convey to our students. So is it open public, is it restricted or even closed? But even if it's closed, it should be kept and archived somewhere for the course of scientific integrity. So we point to trusted repositories like the data centers. But the other thing is, and we also could teach them about this, perhaps not at bachelor level, and maybe less at master level, but certainly at PhD level. So what are the appropriate data use agreements that you need if you have data sets with personal data? So how can you guide people through that minefield and get them there? So one of the areas where you really have to deal with very sensitive personal data, and even in the domain or in the categories of special category data, when it comes to the GDPR, is pathological speech data. And you can imagine it has a medical aspect and so on, and it's hard to get this data. But you also want to share this data. And typically when it comes to special category data, every sign goes on to red and say you can't share it. But if you have consent, okay, it's okay. But again, as a university, you can share this data on the basis of public interest. Please go for that form. So what we have installed or started is an initiative called DELAT. Swedish speakers will know if it's about sharing data. And we offer by this initiative, and it is a CLARIN initiative related also to a case center for atypical communication expertise, where we offer guidelines of sharing this type of data, not only processing or annotating them, but also sharing them. And we offer materials to do this, but also guidelines on which data samples can be used to deposit such data, but also on which consent forms could use, because it's not that if you have say it's public interest that you do not need consent forms, because from an ethical perspective you still need them, but it has consequences for what you write about what happens to their data. So here we have all kinds of relevant information on our website. It's also interesting that we have a special item, it's not quite here, but we also have a CLARIN resource family page on disordered speech data, where you can find all kinds of resources that are already out there, because if you don't need to collect them yourself, but you can reuse others, that's also very relevant. Okay, here it is, the link to the CLARIN resource center, my family. Then, now let's push the right button. I also in the trainers hub of CLARIN, I offer a course specifically on these topics. It's a kind of course that has three elements. So first I introduce privacy by design, what it all entails, but also in terms of the legal basis of collecting and sharing such data. Then we have group discussions, all kinds of use cases, typically for the site where the course is given. And then we do a data protection impact assessment, a role play, where students take the different roles that are relevant here when it comes, for example, to the ethics people, the legal people, the archiving people, the data subjects representatives, in order to discuss a case where whether or not a data set can be shared in terms of a data impact assessment. And it's always great fun. So I have given these courses, I think now twice in Italy and one in Estonia. You were one of the participants there. And I'm happy to give it other places, because it's a really relevant and interesting material to share. Not only with students, but also with teachers, because they, in these courses, appear to be very active participants. That's what I always notice. I think that's a good thing. So much for this commercial. Thank you.